I think we're ready now to resume. Ms. McCarthy.
Good afternoon, my lord. If I may, I intend to move on to my second, our fallback position in relation to discovery, which is if there is a concept of staleness, why we say it shouldn't apply here. We've set out this argument in our case at paragraphs 78 to 81 for your lordship's note. At paragraph 52 of our case, we've also set out two relevant public law decisions which concern administrative delay. And in short, in particular, the case of S makes it clear that administrative delay in and of itself isn't sufficient to void administrative action. It must amount to conspicuous unfairness. Now, returning to what Lord Glennie said was the right approach in Patullo, only the most exceptional of cases should result in an assessment going stale. And you'll recall, my lord, that I referred earlier to, it was paragraphs 29 and 30 in Jerome Anderson, which observed in relation to how to test the objective element of an officer's discovery, that the controls in the earlier cases were expressed by reference to the principles of public law. And that is the correct approach, because what is happening here amounts to an administrative decision. So any controls should be expressed by reference to public law concepts. And for your note, that's PDF page 1611 to 1612, paragraphs 29 and 30, which I took your lordship to earlier. So again, we say that properly understood, staleness is in fact directed at the assessing officer's discretion to assess, the exercise of his discretion. So if the first tier is to have jurisdiction over this, which obviously we say it shouldn't, but if it is, that should be expressed by reference to public law concepts. Now, as I understand my learned friend's written case, he says that's the wrong threshold. I don't think he says, but if it's the right threshold, then it's passed here. And we say that if it's the right threshold, it's plainly not crossed here when one understands the chronology as is set out in the Statement of Agreed Facts. And just briefly, we say the relevant aspects are that the return was amended in December 2009. HMRC had identified Mr. Tooth as being a Roman Gate participant and was liaising with NT advisors, the scheme promoters, about the scheme. In early 2001, the parties agreed they would await the outcome of Cotter. The Supreme Court decision in Cotter was 6th of November 2013. In December 2013, the promoters conceded the scheme didn't work. The Revenue wrote to Grunberg in March 2014, and between March and May, there was the to and fro of correspondence as to whether or not this was a Cotter case or a Para 27 type case. The Revenue accepted that this was a case that fell within the Cotter Supreme Court judgment, paragraph 27 in May 2014. In July 2014, they wrote to Mr. Tooth to notify their intention to assess, and they assessed in October of that year. And so we say that throughout that period of time, Mr. Tooth was well aware that the Revenue did not agree that the transactions he entered into had the tax effect he claimed that they did. There was no period of time when Mr. Tooth could have thought that the Revenue had accepted the Revenue had accepted that the loss arose. And so we would say this is an instance, if staleness is concept, of the relevant discovery, assuming it was made in 2009, having been kept fresh throughout, and action was taken in 2014. And what's more, bearing in mind that most of the delay between 2011 and 2013 was delay, if you like, that was agreed by the parties, we say that certainly shouldn't count against HMRC in taking action. And we also say that that's the right way of looking at a case such as this, because otherwise what would have happened is Mr. Tooth would have had to have spent time and money fighting the assessment, asking for a review, appealing to the tribunal and so on. But in circumstances where he was standing behind a test case, HMRC can't be blamed for having taken that sensible, practical course of action. That's all I wanted to say on if the concept exists and we say it doesn't, then actually on the facts of this case, Stelner shouldn't be engaged.
Can I just make sure I understand this? That the discovery was made in 2009?
Yes, this is on the basis of the discovery having been made in 2009. Then we say that if, I'm sorry, I can put it another way. If HMRC, on the basis that HMRC first realised in 2009, then if staleness is a concept, we say that in this case, the assessment wasn't stale in any event.
I see. Thank you.
My Lord, you'll see that I have on any view set out in our written case what we say is the proper chronology and when it was that HMRC first realised an insufficiency of tax. And we've talked about the relevance of the Grunberg letters in 2014. I certainly don't abandon that case, but I think, my Lord, that's something that's well understood and it's set out in detail in our written case. So I don't propose spending any more time on it. I think I'd rather move, if I may, to the deliberate inaccuracy issue. So turning on to that issue then, that is set out in paragraph 84 onwards of our written case. I will only deal with this relatively briefly because, as I say, it's a response point for us. We say that the majority of the Court of Appeal was right for the reasons they gave in relation to inaccuracy, and that all of the Court of Appeal were right for the reasons they gave in relation to deliberate and the causation test brought about. I'm going to start by looking at section 1187, and then I'm going to take those three separate tests in turn, if I may. So section 1187 is in the hearing bundle at PDF 883. And my Lord, you'll see that section 1185 through to 7, in fact, deal with circumstances of where a loss of tax is brought about carelessly in relation to 5 and 6, and then deliberately in relation to 7. In this act, reading from 1187, a loss of tax or a situation brought about deliberately, references to a loss of tax or a situation brought about deliberately by a person include a loss of tax or a situation that arises as a result of a deliberate inaccuracy in a document given to HMRC by or on behalf of that person. We say that section 1187 is very precisely framed as a deeming provision. And in fact, you can see that from paragraphs 85 to 87 of the Court of Appeal's decision, where the Court of Appeal sets out the relevant explanatory note. And we can see that text just at PDF 170, that's 85 to 87. The relevant explanatory note is quoted at 85. Where a loss of tax or situation is brought about by a deliberate inaccuracy in a document, it is to be treated as brought about deliberately. So turning to the first question, was there an inaccuracy? We agree with the majority of the Court of Appeal and say that whether there was an inaccuracy in a document is a technical hard-edged question. In this regard, it's relevant to appreciate two further provisions. First of all, section 1131 TMA is set out at PDF page 879. Form of returns. Any returns under the Taxes Act, so this is 113 sub 1, any returns under the Taxes Act shall be in such form as the board prescribe. At the next section it's relevant to take into account is on PDF page 842. That's section 8, 1H little a. the Commissioners shall prescribe what constitutes an electronic return. So it's up to the Commissioners to set the format of a return and indeed the format of an electronic return. Please could I ask your Lordship to go to PDF page 454. This page is the front sheet of the material that was submitted to HMRC, and you'll see at the top it says Internet on the left-hand side, right at the very top, Internet hard copy, page 1 of 34, and it's the entire return. If I could ask you please to scroll down to PDF 455, you'll see that in the middle of the page by the right-hand column, how to fill in this form. It says this: the form is designed to be read by a machine. Please follow the rules below so the tax return is read correctly. So pausing there, the question of whether there's an inaccuracy in the return has to be determined by looking at the precise words of the statute as against the background where it's for HMRC to prescribe the form of the return. And they have done so in such a way that it's clear, and this instruction is communicated to the taxpayers, that the return is to be read by a machine. So against that background, we say there's no basis for giving the words in section 118 anything other than their plain and natural meaning. Whether there is an inaccuracy in a document is determined simply by looking at each entry on its own terms and asking whether any of them are wrong. So we agree with the majority of the Court of Appeal that it's not the whole return approach, the whole document approach. You simply have to identify if there are individual inaccuracies in the return. Now, whether or not the return is correct as a whole, on any view we say actually goes to the question of causation, because if the return is correct as a whole, then there's no insufficiency. So that's why we say it's the wrong way of looking at this. And there's nothing offensive about this reading, because a return might be littered with inaccuracies, but if there's no overall insufficiency, then there's no basis for HMRC to assess. The taxpayers suffer no consequences. Now, Mr. Tooth has said below, and this is addressed by the Court of Appeal, how can the return be inaccurate if I was forced into completing it in this way? And we say two things. First of all, the submission is factually wrong, and the Court of Appeal deal with this at paragraphs 77 and 79. We say it's factually wrong for three reasons. First of all, Mr. Tooth could have filled out a paper return. And if he'd done so, he could have filled out the box he wanted to AI3 manually. Now, he complains that this would have subjected him to a late filing penalty, but we say that's not a proper complaint. That's not a reasonable complaint in the context where he has paid, and we know this from PDF page 526, he's paid £132,000 to use a scheme. He can't reasonably say, well, £100 penalty to fill in my return correctly. That's the threshold I can't cross. Secondly, Mr. Tooth could have filed a paper return without the claim, or even filed an electronic return without the claim, then written to HMRC separately seeking to amend it. Now, the evidence below was that Mr. Tooth's accountants weren't aware of this possibility, but it's clear from the instructions to the scheme promoters that this was actually one of the possible ways that they said a loss could be claimed. So this is clear from PDF page 531. It's the last sentence just before the heading at the bottom, claimed to reduce payments on account. The promoters themselves say if your 2007-08 tax return has already been filed, you must notify HMRC of the changes you wish to make in the entries on that return by letter. And finally, Mr. Tooth could have done what the taxpayer did in, for example, the Supreme Court case of Derry, which is to make the claim on the tax calculation pages of his return. So going to PDF page 485, you'll see that's the tax calculation summary pages. So these are the pages that Lord Hodge envisaged a taxpayer completing in the case that was different to the case of Cotter. Just scrolling down, you'll see at the top of that first page, there's a box that says self-assessment. Just for your note, the entries here complete automatically based in entries, based in figures entered elsewhere in the return. So to be clear, it's not that Mr. Cotter wrote in the figure at box 2 of a repayment of 13,000, that filled automatically. But if we scroll down to the next page, the second page of the tax calculation summary, PDF page 846, you'll see adjustments to tax due. And that says you may need to make an adjustment to ... decrease your tax for 2007-08 because you are, reading ahead, carrying back to 2007-08 certain losses from 2008-09. And then there are boxes to write in the figures. So box 15, unfortunately, it's not very clear, but it says any 2008-09 repayment you are claiming now. And then in any other information, Mr. Tooth could have completed that box. My lord.
I'm sorry, I seem to have gone to a wrong page. Did you say 846?
Oh, I'm so sorry. I said 486. My mistake.
Ah, thank you. Thank you.
So I apologise. 486, adjustments to tax due. So we say that whether Mr. Tooth or his accountants appreciated it or not, there were, as it happens, 3 ways that Mr. Tooth could have submitted his returns. So it's inaccurate for him to say, well, there was no other way I could do it. We'd also make the point that even if, as a matter of fact, there was no other way that Mr. Tooth could have submitted his claim, that does not make his return correct on any view. His return is still wrong, although you may say, oh, well, there's a reasonable explanation for why that is so. So that does not detract from the fact that there is nevertheless still an inaccuracy in the document. Now, if Mr. Tooth had done any of those things, then the effect of that, per Cotter, would simply have been that he would have made a standalone claim. HMRC issued an inquiry into what they believed was the standalone claim, a Schedule 1A inquiry. As it happens, that inquiry still remains open. Mr. Tooth has not accepted that tax is due on that basis because he says that in fact he should be treated as having a different outcome. But the only reason he is entitled to a different outcome is because of the entries that he put in the partnership pages. So what Mr. Tooth is trying to say in order to say there's no inaccuracy at all is he's saying, well, disregard the boxes because the information that he added in the white space is in fact how the return should be read. So we say in the context that's wrong anyway, because we know that the return is designed to be read by a machine. We know that the legislation focuses very clearly on an inaccuracy in a document, not an inaccurate document as a whole. But on any view, he says, well, I should be treated as if my entries are in fact in accordance with what I wrote in the white space. And so we can see...
There's an issue sort of underlying this, which also sort of underlays some of the discussion in Derry, which really is the extent to which the commissioners can use software to prevent people from completing tax returns in what they believe to be in accordance with their duties under the legislation governing a tax return. I mean, effectively, he's being driven by the software into completing his return the way he did.
Well, but we would say, my lord, that's not correct for the reasons that I've already given. He could have acted in 2 ways outside the return to do what he wanted to do.
Why should he? But why should he? If he wants to fill in his tax return using the electronic facility that's provided, why shouldn't he?
And my lord, at page 486, I've shown you the way that he could have made that submission using the electronic return.
Could you just help me? Can you just space which he did?
Yes. So there are two entries. The first entry is on PDF page 460.
460, yes, I've got it.
460. So
Now,
this is
that's
the
a white
first
space under any other information.
Yes. This is
Why
the
should it
first.
be assumed? Why should it be assumed from page 455, where it says this form is designed to be read by a machine, sub silentio, that the machine can't read what's in the spaces?
So, my lord, we'd say that there are two separate issues. The first issue is there an inaccuracy in the document? And that is simply asking one to look at every entry in the document and work out if any of those entries are wrong. And we say the moment that...
What other document would you treat in that way?
Right.
Well, if I may perhaps go to... if I may...
What your argument really, I think, comes to is that because the document is being read by a machine which cannot think and cannot apparently read what's in the white spaces, the taxpayer has to bear the risk that the machine misunderstands what he has actually written because it ignores half of it.
Well, if I may do this in two stages, please. The first stage is to go back to the wording at 118. So that's PDF 883. And what we can see from 5, and in particular from subsection 6, is that in the context of carelessness, that is framed in terms of talking about inaccurate information. But 7 is framed in terms very particularly of focusing on an inaccuracy in a document, not inaccurate information, or alternatively, an inaccurate document. And we say that the difference there is very deliberate. We say that the focus, as the majority in the Court of Appeal said, we say that the focus is very much on look at the document, is there an inaccuracy in it? Now, the taxpayer is protected because if the document that the taxpayer submits overall does not contain an insufficiency, then there is no consequence. So a return can be littered with inaccurate information, but if overall there's no insufficiency, then there's no consequence, then there's no question of a discovery assessment. But whether or not the self-assessment is insufficient is a different question to whether or not there's an inaccuracy in the document.
But you effectively are having to say that inaccuracy in a document means inaccuracy in any part of a document considered in isolation from the remainder of the document.
Well, I'm simply saying inaccuracy in a document literally means read the document and pick up whether or not any aspects in the document are inaccurate. And so in this case, we say the inaccuracies are partnership boxes were filled in when there was no partnership, and that's known about. I would also make the further point that it's not correct for the reason I've just shown you to say, well, but Mr. Tooth wanted to submit this return. Why could he not be allowed to fill it in any way he chooses? Because there was a way that he could have filled it in so that it wouldn't have been inaccurate on the tax calculation pages.
There are a number of questions to be put to you. I think Lord Leggett has had his hand up the longest.
Interpretation. Do we not have to keep in mind the context? And the context is, as I understand it, that a deliberate inaccuracy opens up a 20-year time limit. So that surely suggests that it should not be interpreted in a sort of nitpicking way, that filling in one box, knowing that to be incorrect, is a deliberate inaccuracy. If the overall document wouldn't mislead anyone and wasn't intended to mislead.
So there are 2 points to that. Well, there are 3 points to that in total. The first 2 points are, as I'll come on to, deliberate is not to do with fraudulent or culpable conduct. And when you look at section 36(1)(a), it's clear from that that the 20-year time limit can bite in cases where a taxpayer has acted wholly responsibly. And I'll come on to that as part of my submissions in relation to deliberate. So what we say, it's not a question about culpability, it's a question of who should bear the risk of the tax return in fact being wrong. And the second point, which I appreciate I've already said, but I'll repeat it. There's no problem, there's no question of a 20-year time limit at all if overall the return is correct. If there's no insufficiency in the return, then there's no issue. The return can be littered with inaccuracies, but there's no consequence. The third point that I want to make in relation to this is, which I was coming on to, when you look at the white space, it's clear that what Mr. Tooth is saying is, I want this to be read as if I have made a claim in accordance with section 128 of the ITA. Now, such a claim, on any view, and we know this from Cotter, is a claim that falls outside the return. But Mr. Tooth doesn't want his return to be read in that way, because if it is read in that way, then, in fact, HMRC already have proper inquiry coverage under the Schedule 1A. So what Mr. Tooth is in fact trying to do in this case is he wants to say, well, there's no inaccuracy in the return because of the words that I've written in the white space, but I still want to take advantage of the consequence that flows from my having completed partnership boxes, because he has only reduced his self-assessment because and only because because of the completion of the partnership boxes, because that is how the return works. So it is only by essentially saying in the boxes, I'm claiming a partnership sideways loss. That is the only thing that has given rise to the consequence that his self-assessment reads minus 13,000. So he actually wants, Mr. Tooth actually wants to have it both ways. He actually doesn't want the treatment in the white space, because the treatment in the white space means that this case is a red herring, and actually HMRC have opened the right inquiry under Schedule 1A. So he actually doesn't want the white space treatment. What he actually wants is a hybrid of read the boxes to give me the reduced self-assessment, but read the white space to say that I haven't made an inaccuracy in the return. And the one thing he can't have is that hybrid treatment. Yes, my lord.
I've been flicking through this tax return. Where is the signature page, please? Mine seems to stop at page 33, and I rather think it's on page 34.
One moment, if
33
I may.
is at 33 is at 487, and we then, I think, get into the notes, don't we?
Yes. One moment, please. So in fact, the signature, well, it's in the case of an automatic self-assessment, the declaration is on the first page.
Ah, which is page 455.
I'm sorry, I'm just getting to it. It's page 455.
Yes.
No, I'm sorry. Forgive me. That's not quite right. Forgive me. The signature page is on page. Yes, here we go. 460. So it's actually the last page of the tax return pages TR6. But in circumstances where you're filing an electronic return, you don't actually sign the signature page.
Right. But what he says on page 460, and what you have to say, that the information I've given on this tax return is correct and complete, to the best of my knowledge and belief. There's an obligation to make it complete. And if there are white spaces all through this document, and is it not the natural assumption for someone seeking to fill in this document that if for any reason he can't put down the whole of what he thinks he ought to put down as a complete return within a box, he has to do it in the white space? That's what they're there for.
So can I take 2 points, please? The return, it's up to a taxpayer as to whether or not they choose to make a claim. So his return, as a matter of fact, would have been perfectly correct and complete in circumstances where he simply left the claim out. There's no obligation on him to make a claim. He's chosen to make a claim, and we say that the legislation requires looking at 3 things separately. Is there an inaccuracy? And we say that that doesn't look at the separate question as to whether or not it was deliberate, and it doesn't look at the separate question of causation. We also say that section 29.4, which deals with the 2 conditions, is on any view separate from section 29.5, which is to do with disclosure. So simply looking at the stage 1, is there an inaccuracy in a document? Putting the point another way, so forgetting for the moment this case, if one was talking about a case involving carelessness and penalties and so on, what you may say if disclosure has been given is, well, yes, there's been an inaccuracy, but there's no penalty because there's a reasonable excuse, because look at the explanation in the white space. But he wouldn't simply leap to saying, well, there's no inaccuracy at all. But on any view, my lord, I think the point still remains, Mr. Tooth does not want to be treated on the basis of his white space disclosure, because his white space disclosure says in 2 places, page 460 and in relation to the partnership pages, I am claiming loss for which relief is being claimed now in accordance with section 128. But Cotter tells us that a claim in accordance with section 128 is a claim outside the return. So he's perfectly able to write it there. He just can't have the benefit of it filtering through to alter his self-assessment. And I think this is key. Mr. Tooth does not want to be taxed in accordance with the additional information, because if he's taxed in accordance with the additional information, then HMRC have covered that with their Schedule 1A inquiry. So he does not actually want this return to be read solely by reference to what is in the white space, and that is critical.
But has Mr. Tooth ever said in writing or in any other way, I don't want to be taxed in accordance with the disclosure in the white space? May or may not have appreciated that may have a consequence in terms of the Schedule 1 inquiry. But as I understand it, the revenue was accepted without qualification that the Schedule 1 inquiry was deficient. It's not that he's said your Schedule 1 inquiry is deficient, because I'm not asking you to rely on what's in my white spaces.
So actually, Mr. Tooth, I think I was speaking more metaphorically. He doesn't want to be taxed in accordance with the white space. The circumstance here is the Schedule 1A inquiry is in fact still open. HMRC accepted that that was not the right route on the basis of Mr. Tooth's submission, that because he had filled in, and he didn't say this literally, but because he had filled in the partnership pages, and that had the effect of reducing the self-assessment, then actually this was a situation to which paragraph 27 of Cotter applied, and he should therefore be treated as having reduced his 2008 self-assessment. So when I say he doesn't want to, I mean metaphorically speaking, he doesn't want to, because otherwise it's a Pyrrhic victory in essence, Pyrrhic victory, because the Schedule 1A inquiry is still open. That was never closed. So it's important to recognise that it can't be the case that the white space here cures the inaccuracy, because the white space here is not capable of curing the inaccuracy. All the white space here is capable of doing is saying, well, assume I've made an employment loss claim. But if you assume he's made an employment loss claim, then that doesn't have the effect of reducing his year one self-assessment. Now, what he can't do, because as I've shown you in the legislation, it's for HMRC to prescribe the form of the return. What he can't do is metaphorically take a red pen to the top of the partnership pages and cross out the headings and write in employment loss pages. He can't do that because it's not for Mr. Tooth to prescribe the form of the return. So Parliament has delegated to the Revenue to prescribe the form of the return. They have done so. If Mr. Tooth wants to complete his return, he has to do so on the form that has been prescribed by HMRC. He has chosen, and it's been a choice because there were other ways that he could have made his claim, he has chosen to fill in inaccurate boxes. That can't be cured in circumstances where, on any view, he does not want to accept the consequences of what he has written in the white space anyway. The white space does not cure the inaccuracy in the return.
It isn't really to do with prescribing the form, is it? Because you accept that he could fill in the paper version of the form.
But my lord, I think if he had filled in the paper version of the proper form, then he wouldn't have had the problem. He would simply have completed the A13, and the notes accompanying the paper version of the proper form would have enabled him to complete the rest of the form, essentially in the way that Mr. Cotter completed the form.
Yes, but I mean, I don't really see where the Commissioner's discretion as to prescribing the form of a return comes into it.
Well, it comes into it because we say what he can't do is metaphorically take a red pen to the headings on the partnership pages, cross that out and write employment loss pages. So in making entries in those partnership pages, that is what he is taken to be doing. He has made those entries. Those entries are inaccurate. Those entries, and only those entries, because of the automated nature of the return, are what leads the self-assessment at in the box 2 on the tax calculation pages to say -13. If he had created an electronic, if he had not suffered the software glitch, those boxes would not read -13. And that was the evidence below, and those were the findings of the tribunal below, and that is clear from the form. The boxes on the TC pages auto-correct. So the only reason that box at box 2 has the essentially repayment of 13 figure in, the only reason is because of the entries on the partnership pages. If Mr. Tooth had not made those entries, then he would have had a figure of 465, as the case may be, in box 1.
But are you saying there was no way he could have, without making a partnership loss claim, secured for himself a self-assessment in the lower amount? I take your point that the computer might not have done it for him, but could he not put something in by way of addition to what the computer did to say, in fact, I'm saying that my self-assessment should be -13?
Well, in theory, he could have written those words in the white space, and then we'd be having a different argument as to whether or not words in the white space could in fact alter his self-assessment. So if the question is, so just returning to page 485, if the question is, could he have made any numerical entries in his return that weren't obviously wrong to get that -13 figure? The answer is no, he couldn't have done. That -13 figure exists. It's automatically computed. It exists only because numbers were written in the partnership pages. if the software glitch had not arisen, those numbers would, and he had completed the boxes that he wanted to complete, as NT advisors had instructed him, that would have shown a figure in box 1 of the self-assessment page of 485 odd. So what Mr. Tooth could have done, in the sense of, if this is the information he wanted to communicate, he could have said, well, that's what box 1 says. I'm going to complete the adjustments to tax due, box 15, and the other information on TC2. And then there would have been an argument akin to the second issue in Derry. Well, what does that mean since he's made those entries? But the only way, and this is critical, and the Court of Appeal accepted this, and this has been in the evidence below, the only way as a matter of fact to get that -13 figure was to enter numbers in the partnership pages. And that's just a hard-edged, objective, factual question.
But I think you're accepting, aren't you, that he could nonetheless have gone on in an appropriate white space and said, in fact, although the computer is insisting on self-assessing me at £485,000, I'm actually self-assessing myself at -13 because of my claim. And that's what self-assessment means. It's your own assessment of your tax liability.
Well, but critically, my lord, we say that that's not actually what he's done, because what he's done is he has simply written, I make a claim in accordance with section 128.
I accept that, but my question to you is whether he could in fact have self-assessed himself at -13, even though the wretched computer insisted on putting +485 in the box. If he,
so,
I think you previously accepted he could do, and then he would not be charged. I mean, he would be treated as having self-assessed himself at that lower amount.
I think what the Revenue's position would be, and by all means overnight I'll take instructions on this, I think that what they're saying is, well, they wouldn't accept that that was possible because you have to use the form as prescribed. Now, whether or not it would be possible for a taxpayer to make a wrong amendment is a separate question that doesn't arise, because that's not what Mr. Tooth has done here. So if the question is, well, is it possible that he could have simply written a separate letter to say, I've sent in my self-assessment return, I want to amend it so that my self-assessment is in fact -13, and the reason it's -13 is because here are these things, then that's fine. But that is not what Mr. Tooth did here. That would be a case that's different to Mr. Cotter, because Mr. Cotter didn't go far enough in his amendment. He didn't seek to recalculate his tax.
He didn't need to, because the computer came up with the right figure.
I'm sorry, in Mr. Cotter's case.
I'm sorry, I'm confusing Mr. Cotter and Mr.
No.
And Mr. Tooth. Yeah.
Yeah, the computer came up with a figure that he considered to be his self-assessment.
Yes.
But my lord, the only reason that happened, and we can see this also from the tax calculation summary pages, is because what he has actually done is essentially made a partnership sideways loss claim in filling in the partnership pages of his return. Now, I'm conscious that that because of the questions in relation to inaccuracy, I'm coming up to my time now. I haven't covered deliberate, and I haven't covered the causal point. These are both set out in our written case. And just in terms of deliberate, I'd make 2 points, which is, it's clear we say deliberate is not tantamount to fraud. And the reason we say that is clear is because Parliament deliberately, intentionally stepped away from the wording of fraud and chose the wording of deliberate. We'd say deliberate in and of itself does not carry any notion of culpability.
Well, can I
the other point.
deliberate is contrasted in the legislation with careless, which is defined as a lack of reasonable care. So careless is culpable.
It is, but...
Well, is there any rationale for raising the time limit, the ordinary 4 years, to 6 years, where there is culpability, but to 20 years, where you tell us there needn't be culpability?
And we say that in relation to the 20-year time limit, the emphasis is on who, as between HMRC and the taxpayer, should bear the risk of the return being wrong. And we say that because the other examples that are given in section 36(1)(a), so that's page 866, the other examples there may be nothing to do with blameworthy conduct at all, as the Court of Appeal correctly recognised at paragraphs 170 to 171. So just taking an example, section 36(1)(a)(b), attributable by a failure to the person, to a failure by the person to comply with an obligation under section 7. Section 7 is the requirement to notify chargeability. If, for example, you've become non-resident, you may have taken careful, comprehensive advice about the status of your residence. If that advice is wrong, nevertheless, and you fail to notify your chargeability, the 20-year time limit will apply. 1(a)(c), attributable to arrangements, essentially DOTAS notifiable arrangements. That is all to do with whether or not specific information has been included in a tax return. You may have taken careful, considered advice, and that advice may be that the arrangements in question are not notifiable. Notifiable has a certain statutory meaning. If that advice is wrong, you're within the 20-year time limit. And the fact that you took advice and the fact that you acted reasonably doesn't save you from that. And so we say that the section 36(1)(a) time limits are not to do with culpability, they're to do with circumstances in which Parliament has decided that the taxpayer, rather than the revenue, should bear the risk of the return being wrong. And in relation to a deliberate inaccuracy, we would say, well, you've completed a return, Mr. Tooth or his advisors here knew full well that he didn't have partnership losses. They knew full well that he didn't have losses in 0708. They knew full well there was no partnership with a UTR of 10 nines or otherwise. They knew when the return went in that those 2 pages were inaccurate. And the result of that is that in that circumstance, if you know that you have given to HMRC a document that contains inaccuracies, Parliament has determined that in that scenario, you should be the one that is bearing the risk of it being wrong. The only other case that I'd just like to mention, and I'm conscious of time, is simply the case of West, the Upper Tribunal decision in West, which deals with willfully failed to deduct PAYE. That's at PDF 1573. And the situation there, very briefly, was that Mr. West was determined to do the right thing. He'd taken professional advice, but as a matter of law, what he had done did not amount to a deduction. And so therefore, the Upper Tribunal concluded, and that was the then Chancellor, Lord Justice Voss, Mr. Justice Voss as he then was, that was a willful failure. And essentially, the Upper Tribunal says at page, let me just find the reference if I may. Essentially, the Tribunal's reasoning was that you don't have to intend the legal consequences of your actions in order for them nevertheless to be willful. And just for your Lordship's note, that's PDF page 1590. At paragraph 66. And also paragraph 64 on the previous page. For a person willfully to elect a particular legal outcome, it's not necessary for that person to be cognizant of the legal consequences of his or her actions It's necessary only for that person intentionally or deliberately to put in train the various actions that in the event have the material consequences in law. And we say that that is exactly what happened here, because the one thing that I think is common ground, is accepted by everybody, is that Mr. Tooth's advisors knew full well that he did not have a partnership, he did not have a partnership loss. And yet those actions, completing those boxes, were the actions that put in train the relevant legal outcome here, and the only actions that that resulted in that outcome. My Lord, I'm conscious of the time, so I've gone through those submissions very quickly. But as I said, they're set out in detail in our skeleton argument, and ultimately we're simply adopting the judgment of the Court of Appeal, the majority of the Court of Appeal in accuracy, and the Court of Appeal on the remaining two factors. So unless your Lordship has any further questions, I think I should end my opening there.
Thank you very much indeed, Ms. McCarthy. It's certainly, you don't waste time by answering our questions on the points that are troubling us. Well, that's very helpful to us. I'm afraid we had an interruption of the live streaming of our hearing for about 5 minutes just now, during which Ms. McCarthy was completing her submissions. I hope this is now functioning properly, and that in particular those instructing Ms. McCarthy and Mr. Ghosh and their junior counsel are able to follow the proceedings and get in touch with them if they need to. If we have any more problems, do Ms. McCarthy and Mr. Ghosh, do please let me know, and we'll pause until they've been sorted out. In the meantime, I think we're ready to hear you in reply, Mr. Ghosh.
I'm very grateful. Please may I check that all of your lordships can hear me?
Yeah.
I'm grateful. Please may I make these preliminary points. One, it is important in my respectful submission to have a firm grasp of what this case is about. In other words, the issues at stake. The issue on discovery is whether the discovery assessment is made on proper grounds, and the proper grounds are to do with an insufficiency of tax. In other words, whether the amount that Mr. Tooth self-assessed for was wrong. It is not to do with the correct method to disturb that self-assessment. So whether the revenue should have gone about disturbing Mr. Tooth's self-assessment using Schedule 1A or rather Section 9A, that is a different question. And the short point, the burden of this is on the revenue, is that the revenue have got to identify a discovery. And the short point is they haven't at no stage in these proceedings. Even now, after Ms. McCarthy's submissions this morning, they have not identified a single occasion of having made a discovery. The other issues at stake, equally important, conceptually, as it happens more so, is to do with the complaints about Mr. Tooth's return. That's to do with whether there was an inaccuracy, whether that inaccuracy, if there was one, was deliberate, and what did it cause? Did it cause an insufficiency of tax? An insufficiency meaning, was there a deliberate inaccuracy that gave rise to the wrong number? And then there's staleness. And just about staleness, Ms. McCarthy's right. Staleness presupposes that there's been a discovery. And this is a point already made by my Lord Reid. The question of newness is actually relevant at two places. One is whether there has been a discovery in the first place. Secondly, and separately, does the effluxion of time mean that a discovery assessment is no longer assessing something new? But that's different. Because, and I say this respectfully and I say this responsibly, Ms. McCarthy did misrepresent my submissions both below and before the Court of Appeal, because my complaints about the revenues case about newness were all to do with my complaint that at no stage had the revenue competently, on every meaning of that word, made any pleadings on what did they discover that was new. Those are the issues at stake. Now, I wonder if I may please do this, because it will help me take my submissions short. If I might please show your lordships the Mr. Tooth's tax return. That's really not going to take very long. And then the FTT decision, because that will frame all of my submissions, with your permission. I know you're not a fact-finding tribunal. I'm not asking you to be. First point, at page, it's tab 33, page 485. That's the amount that Mr. Tooth self-assessed for. It was minus 13,000. That's the amount he wanted to assess for. Because I'll show you this. His advice was that the employment loss that he was hoping to get could be carried back to reduce his income for 2007 to 2008. And also, in parentheses, this return obviously went in before Cotter, so there's no question of engineering some sort of hybrid return. That is nonsense in my respectful submission. That figure, so far as Mr. Tooth and his advisors were concerned, was the correct figure, the right figure. And again, tapping into observations made by my Lord Reid, it would have been the wrong figure if that had read 455,000. And tapping into observations made by my Lord Briggs, if it had read 455,000, steps would have had to be been taken by Mr. Tooth and his advisors to correct that, because as far as they were concerned, that was wrong. That's the tax assessment that was self-assessed. Now that's the lot on Mr. Tooth's tax return. Going through, please, with your permission, the first-year tribunal's decision, the FTT's decision. Starting at page 208, evidence and facts, if your lordships have it. Paragraph 7 on page 208. I'll take this short, but it's critical. Mr. Tooth got advice. Paragraph 7 says that. And at paragraphs 8 to 11 on page 209, good short, your lordships will see that Mr. Tooth got advice not only about the loss, but about the loss being carried back. Nothing to do with a claim outside the return or so forth. You'll see that, your lordships will see that in particular, paragraph 11. All to do with reducing a prior year's liability. Do you see that? Now, at paragraph 13, it's at page 210 now. You've got Cotter set out. I'm going to assume, with your lordship's permission, that your lordships are familiar with Cotter, because the whole point about Cotter was that my Lord Hodge, what he said is, look, generally speaking, a claim is made outside of the return. So if you've made it separately to returning a particular amount for a particular year, that's outside that return, even if you make it in the form of an amendment to that claim on the face of it. But if you've self-assessed, and this is the burden of paragraph 27, it's set out to paragraph 13 of the FTT, if you've self-assessed for a particular amount, that's a self-assessment return. In the way that my Lord Briggs put it, that you have actually computed your own tax. That's the whole point. That's what you're supposed to do. Paragraph 15, still on page 210, just while we're here, about the software. Bear in mind, what we're talking about here is that Mr. Tooth thought that the correct figure he wanted to self-assess at was minus 13,000. If the software had spat out 455,000, I've said this once, I'll try not to say it too many times again, that would have been the wrong answer as far as he was concerned and his advisors were concerned. So a complaint that the software spits out the wrong answer is not Mr. Tooth's problem. Looking at paragraph 15, the reason it went into the partnership loss box was because there was the software wouldn't let him put it in to this other box, box AI3. Please may your lordships bear in mind that other box was also, as it were, a wrong box. It wasn't an employment loss box. What the revenue are saying is, but that wouldn't have mattered because that would have let the software spit out 455,000. Well, my respectful response is, who cares? So 15 tells you that the only reason that it went into the partnership loss box was because a software engineer told Mr. McMahon, and Mr. McMahon told Mr. Tooth. That's where the loss needs to go if it can go anywhere. 16 and 17 I can take short. 18, I don't want to make a meal of this, but if your lordships look at the information put at box 30, in my respectful submission, Mr. Tooth could not have done any more. He said, I have put a loss into the partnership box. It isn't a partnership loss. It's an employment loss. I've carried it back. I mean, goodness me, he invited an inquiry. If you turn the page to page 212. And just in parentheses, I respectfully adopt an observation my Lord Briggs delivered. And this is not a rhetorical question. Why should Mr. Tooth assume that the machine would not read that box 30? It's a box in the partnership return. Just one point. at paragraph 20, still on page 212, my Lord Reid, when he was talking about staleness, said there was a confusion of two different ideas. Paragraph 20 actually highlights how the revenue have confused and conflated two different ideas. One issue is the minus 13,000 wrong? A second issue, a different issue, is if the revenue thinks it's wrong, what is the mechanism they should use to disturb it? Because what Mr. March was saying before the FTT was, well, I'm very annoyed because if, and I paraphrase, what is a perfectly good paraphrase, if Mr. Tooth had put that loss into any other box, I'm happy because the software would have spat out 455,000. That's the wrong answer from Mr. Tooth. He thinks that's the wrong answer. And as it happens, Mr. Tooth didn't know that, and his advisors didn't know that. That's a finding of fact. One, on page 212 to 213 tells you that Mr. Tooth delivered his self-assessment. And by the way, on the 31st January 2009, that was too late to deliver a paper return. The time limit for that was 31st October 2008. So by then he couldn't have delivered a paper return. And I may as well make this point now. To suggest that it's a good thing to incur a £100 penalty is, in my respectful submission, again, I say this responsibly, that's a disgraceful submission by the revenue. My Lord Briggs is distracted. Now,
It's collecting another notebook, Mr. Gosh.
Please may I continue? Paragraph 23. This is the 14th August 2009 letter. Short point, the revenue are well aware it's an employment loss straight away, and they knew he was carrying it back because he was using it in 2007, 2008. Paragraph 24, just a short point. It's an observation. This is anticipating what I'm going to be saying about inaccuracy and deliberate behavior. The reason that the loss wasn't available to Mr. Tooth was because of a retrospective statutory amendment in section 1285A of the Income Tax Act 2007. Now, the revenue say, actually relevantly, I'll come to this, that they always thought the scheme didn't work even without section 1285A. That's relevant, but not in a way that the revenue will like. Now, paragraph 25, you've got a note from the FTT that there was an amendment to Mr. Tooth's return. And these then, may I go straight to paragraph 27 on page 214? Because that's when the revenue say, look, Cotter's out now. We think you owe us tax. 28. I'm very sorry, my Lord Briggs. 28. This is the Grunberg letter. So this is supposed to be the trigger of what told the revenue that there was an insufficiency of tax. The minus 13 figure was wrong. Not at all. This was all to do with how do you disturb that minus 13 figure? Should it be Schedule 1A? Or is it Section 9A? Because what Cotter said was, yes, it looks like reversing the Court of Appeal, that Mr. Cotton had self-assessed for a particular figure. Actually, he hadn't at all. He self-assessed for a different figure. This is really a claim. But then my Lord Hodge said, but had he self-assessed for that different figure, that would have stood as self-assessment. Anyway, at 28, you've got Grunberg replying. This is, as I say, supposed to have been the trigger, saying, well, no, Mr. Tooth in fact self-assessed at minus 13,000. You're wrong to say he self-assessed at 455. And then you've got, at paragraph 30, the revenue writing to Mr. Tooth on the 28th of July, at page 214. Now, if your lordships please turn the page to page 215 of that letter, the paragraph that starts, you submitted your tax return. Your lordships will see the first accusation of deliberate behaviour to do with putting the separate, the loss on the partnership page. Nothing to do with Grunberg. Then at paragraph 32, your lordships may see, please, it's 6 lines from the bottom of paragraph 32, you're told that responsibility for the decision to assess was with Mr. Williams. So he's the person who took the decision to assess. He's the person who must have found an insufficiency of tax. In other words, the minus 13 figure was wrong. Paragraph 33 and paragraph 34, you've got an extract of an email exchange. And for your lordships, note the whole email exchange you'll find from page 671 to 674 of the bundle. But paragraph 33 sets out relevantly. At paragraph 34, Mr. Williams, what he says is he doesn't know much about self-assessment. But he wants to make a discovery assessment to replace the Schedule 1A assessment. That's all to do with disturbing the minus 13 figure. It isn't to do with saying the minus 13 figure is wrong. Now, if your lordships read the email exchange at page 671 to 674, you'll see that Mr. Williams had said to Ms. Thorley, who then told Mr. Anders to do this, write a letter. Paragraph 35 is that letter. And your lordships will see the unfounded and improper allegation that he knowingly and deliberately made entries to the effect that the loss was a partnership loss, nothing to do with technical software. That was the foundation that fructified Mr. Williams' decision of the discovery assessment, not Grunberg. And I'd ask your lordships to dwell on that, because for your lordships' note, at tab 76, I won't take you to it, pages 640 to 641, there's what the revenue call a view of the matter letter, dated 19th November 2014, which says that that letter, that October 2014 letter, was correct on its terms. And then at tab 84, page 657, there was a statutory review, which again confirms the reasons given in this letter. Now, this 2014 letter has got, I've said it now, nothing to do with the Grunberg letter and everything to do with this unfounded allegation. Now, please may I fast forward to paragraphs 44 and 45. They're on page 219. Now, picking up on something my Lord Reed observed, I had made a complaint and your lordships will find this. Please don't go to it, but you'll find it at tab 26, page 364, paragraph 13, where I said in terms, I was putting the revenue to proof on having made a discovery. Nothing to do with staleness. And if your lordships read 44 and 45, what the FTT says is, in the first sentence, that's actually addressing that submission. I was saying discovery. What discovery? Where is the conclusion that that minus 13,000 figure was wrong? In any event, separately, in other words. The 14th August 2009 letter was so long ago that if staleness is a thing, then it's stale. And then at 45, the FTT says there was a discovery in 2014. Why? No factual analysis. Is because the threshold is low. And that's what I said before the upper tribunal. That's not good enough. So as I say, that short exposition of the FTT's decision tells us that Mr. Williams' decision, and I do invite your lordships to read page 671 to 674 of the bundle, to issue a discovery assessment resulted in, was fructified by that letter of October 2014. And I've said it now already, nothing to do with Grunberg, everything to do with this improper allegation. By the way, in parentheses, at paragraph 44 and 45, you'll see that when the FTT talked about me saying, look, discovery, what discovery? And in any event, if you're telling me that there was a discovery, it must have been August 09, that's too long ago. If staleness is a thing, then that's stale. At no stage will you see any record of the Revenues then Council, Mr. Appellant, saying, oh, no, 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 we're disavowing August 09. It's all to do with the Grunberg letter of whatever it was, 11th March 2014. And just to deal with one short point that my Lord Briggs made, that he put to Miss McCarthy. He said, oh, if your lordships are with the Revenue on staleness, then it won't matter to them whether the discovery was August 09 or October 2014. Well, as far as that goes, of course, that must be right, but they've disavowed August 09. They're not saying August 09 was a discovery event. Their permission application said that it's been their case all along, their words, that it was the Bloomberg letter of March 2014 that triggered the discovery. Just if you want a reference for that, it's tab 25, page 342, paragraph 8. Now, my lord, your Lord Reed is on mute.
I'm so sorry. You think I know by now? Can you remind us what document is it that paragraph 8 comes from?
It's the Revenue's application to the upper tribunal for permission to appeal.
Thank you.
Now, before I make my submissions on discovery, and please may I make good my submissions on the archaeology of where discovery assessments fit into the compliance regime. Now, the way the compliance regime works is that I'll show you this, but it's again, it's quite straightforward and short. So if I make my submissions, then I'll show you the provisions. Taxpayers now have got to make returns, depending on what sort of taxpayer you are. The revenue can inquire into that return, and that return has got to include a self-assessment. So what the revenue inquire into is your return, which has computed your tax. What if the revenue choose to inquire, they will close that inquiry with a closure notice. Stating their conclusions as to why they disagree with your self-assessment, your self-computation. That's what gives finality. That's why the burden of proof on a discovery assessment is on HMRC, because that's it. It's only then, if and only if, a revenue officer or the board separately discover an insufficiency of tax because of either new evidence or a different view of the law. And that's section 29. So you've got an archaeology of return, including self-assessment, followed by inquiry, followed by closure notice. And that is what Lord Justice Moses described, and I'll just give your lordships the note, in Taurem Cashback at paragraphs 3 to 6, and that's set out in another case called Hankinson at tab 36 at page 126 to 128. So then please, if I show you the provisions. So for Mr. Tooth, because he's an individual, he starts off with this obligation to make a personal return. That's at section 8. That's at page 841. The time limits which is why he couldn't make a paper return. They're in section 8.1 capital D. The return has to compute his tax. It's got to be quite literally a self-assessment of his tax liability. That's in section 9. That's on page 844. Then if the revenue want to inquire, they raise an inquiry and they do that by notice. That's section 9A. That's page 850. And once the revenue is satisfied that they know what the right answer is and they want to disturb that self-assessment, they close the inquiry with a closure notice, and that's section 28, capital A, page 858. That is what explains something that my Lord Briggs was asking to do with what is a discovery. And both my Lord Briggs and both my Lord Reid were really scrutinizing, interrogating this. And if your lordships please look at page 860, section 29. It's 29 is little one. It's if an officer of the board, or in contradistinction, the board. So I think insofar as it doesn't really matter in this case, but you can't say that every time an officer discovers something, the board is doing it through that officer, because that makes that distinction between the officer and the board meaningless. But I really don't have any emotional commitment to that point. So I think I'll pass on to something which is important. Discover. Now, discover relative to what? And this is where the archaeology of the self-assessment provisions matter. Now, section 29 was there before self-assessment, in the days where the taxpayer had to deliver a return, but not a self-assessment, and then the revenue, if they didn't, would levy an assessment, which the taxpayer would either just agree with or appeal against. That's changed. Now, section 29 is properly applied to and should be construed by reference to the self-assessment regime, which says it's the taxpayer who self-assesses. The revenue have the opportunity to raise an inquiry and close it. Whether or not they've raised an inquiry, they can raise this discovery assessment if they discover what? An insufficiency of tax. The number is wrong. Now here, you go back to that minus 13,000 figure and ask, at what stage, if ever, did the revenue discover, as opposed to being told that Mr. Tooth's number differed from their notional correct number? And that's why I said it was relevant that the revenue themselves say, we always thought this employment loss was bad. We always thought that Roman Gate didn't work. For your lordship's note, it's page 36, footnote 11. It's of the revenue's written case. And this goes to a point raised by my Lord Briggs. Because Miss McCarthy said repeatedly, a discovery must necessarily have been made. The only question is whether it's stale. No, I don't think that's right at all. And here, in the world of self-assessment is not a game. It's a point made by my Lord Legate. Not only was section 1285A retrospective, section 1187, on which the revenue rely for deliberate behaviour, that's retrospective. So somebody who submitted a return in 1992 is subject to 1187. It wasn't in effect, actually, when Mr. Tooth submitted his return in January 09, or indeed his amended return in December 09. What does that mean? If an officer of the board discover there is an insufficiency of tax, I say, and this is also what the cases say when they talk about something new, discover in contradistinction to what was thought about the previous assessment to tax. It must mean that. They thought a number was right or different to what they've discovered it to be. Because the insufficiency of tax is only visible on the face of either in the old days, the revenues assessment, or now on the taxpayer self-assessment. So, and here, like I say, it's not a game. If I'm teaching my students, and I tell them something about the law, in my respectful submission, they haven't discovered it, I have. Or if Einstein's discovered X and he tells somebody else, they haven't discovered it, Einstein has. The mere conveying of information, to be the recipient of information, is not to discover it. But the elasticity of the word discover it needs to be made for purposes of legal certainty, something which is, and I agree here with the revenue, practical, predictable, that will give rise to consistency. And that means it's a world where the revenue thought the number was X, and an officer thinks now the number is not X. Not the revenue software. The person deciding to raise the assessment thought that the taxpayer had self-assessed at X, and now they think, well, and that was their view. Now they think, I've got a different view. They've self-assessed at X. There's an insufficiency. They haven't self-assessed for enough. Now, in my complaint that the revenue changed their case loads of times, the original statement of case talked about how it was Cotter. And this is all in my statement of in my written case, so I won't take you to it. But they thought it was Cotter. That's it. You'll find that at page 398. Then they said, well, it's not Cotter. It was October 14. Then they said, oh well, it was always the Grunberg letter that somewhere gave rise to a discovery. That was eventually made in October 2014. Discovery that they have to make good, they have to plead, and the burden's on them, is a conclusion that that number of minus 13 was wrong. And I'm asking, where is it?
Can I ask you, Mr. Ghosh, before you move on, you took us to the scheme of self-assessment with the provision for making an inquiry under section 9A, and I think there's a time limit within which that has to be done, isn't there?
Yeah.
I suppose construing the discovery assessment provisions in the context of section 9A, they can't, I suppose, be intended simply to be an alternative means of of performing the same function.
I respectfully agree. And the interesting point is that that inquiry process has nothing to say about discovery. It doesn't use the language of discovery, not at all. It's an inquiry. By definition, finding out new things. That's what an inquiry is. So I respectfully agree with your Lordship's observation. This optionality that, oh, well, I absolutely know that I'm going to attack your self-assessment, but for whatever reasons of my own, I choose not to raise an inquiry. I choose not to close that inquiry. I'll use a discovery assessment instead. Well, I mean, I don't know how to describe it. It's a silly proposition. Tim Norton actually doesn't address the point, because when you put the point to Miss McCarthy, I think it was my Lord Briggs who talked about optionality and said, well, are you saying the revenue's got the option? The answer, oh, well, the revenue are entitled to raise the discovery assessment within the inquiry period, doesn't answer that question. Because what that tells me is that maybe if the conditions are satisfied, the revenue during the inquiry window may have some sort of option to raise an inquiry, or within the inquiry window raise a discovery assessment. But the different circumstance where I've got the option to, I absolutely know I disagree with this self-assessment. That number's wrong. And I'm simply choosing to leave it and make a discovery assessment. That's not answered by Tim Norton, and if it is, it's wrong. Please, my Lord Legate.
Not obvious to me why the proposition's so silly, as you describe it, when an inquiry, as was pointed out, can be just a speculative type of investigation, whereas to come under Section 29 and make an assessment there, you have to fulfil certain quite more stringent conditions that satisfy in particular one of the first or second conditions. So they can live quite happily alongside each other, can't they?
They can live alongside each other, which is why I said in a case like Tim Norton, where you're within the inquiry window, I don't have any objection in principle to a discovery assessment being raised within the inquiry window rather than the inquiry.
Why should the inquiry window be the cutoff for making a discovery assessment? And follow that.
It's for this reason, my lord. What I described as the archaeology of self-assessment is the return, including self-assessment, opportunity to make inquiry, close that inquiry. That achieves finality subject to discovery. And what the burden of my submission on this point is that finality is disturbed if and to the extent that the law gives the revenue optionality. That's what I'm saying. What Lord Justice Moses was saying in Towdown Cashback was, he says, look, we've got a system here where the tax return's gone in, there's a self-assessment, the revenue got the opportunity to inquire and close that inquiry, and once that has gone, that is final, subject only to discovery.
But if you're the taxpayer, you've no idea whether, when that period is gone, in terms of your certainty, you don't know whether somebody within the revenue might have spotted an error, not done anything about it, or whether they don't spot it until a year or so later. So there's no certainty, as it were, either way. Your case depends, doesn't it, on an internal inquiry then going on into finding out when knowledge first came to somebody's attention, which is happenstance as far as the taxpayer is concerned.
It might be, but that is confined because of the time limits on the inquiry. That's exactly the point I responded to my Lord Reed's observation. Absolutely. I mean, in that sense that your Lordship has put to me, that my Lord Legate has put to me, the fact of the revenue disagreeing with the self-assessment is always going to be happenstance. Different officers may take different views of the law, but the inquiry window, the reason I'm putting pressure on that, gives a time limit for the revenue to raise the inquiry, and then once they've raised it, they will decide when to close it. If they haven't raised it within the time limit, the only other avenue to disturb the self-assessment will be the discovery assessment provisions if the conditions are satisfied. So the point I'm making is actually a very simple one. The revenue have got the opportunity, because I'm construing the word discover. That's the point of this part of the conversation. Discover, by reference to what? Discover knowing that there's been a self-assessment included in a return, an opportunity to make an inquiry, and if an inquiry has been raised and closed, discovered after that. If no inquiry has been raised and the inquiry window has come and gone, discovered after that. That's my point. That if I'm asking what does discover mean, and bearing in mind, as I've said, the inquiry process doesn't use the language of discover. There you've got the revenue trying to find out all sorts of things during the course of an inquiry. We're trying to discover relative to what? And here, the thing they've discovered for this to be a good discovery is an insufficiency of tax. The number is wrong. And I am saying, looking at what I've shown you, there is no evidence that the revenue ever discovered, in the sense of found out, in contradistinction to anything, that minus 13,000 figure was wrong. You can make inferences, you can make speculation, but the burden here is on the revenue. They have got to be able to show the FTT, it's the fact-finding tribunal. Here's when we thought that the 13,000 figure was right. Here's where we thought the 13,000 figure was wrong. Please, my Lord Picks.
Mr. Bush, you said a few minutes ago, discovery must be of something different to what the revenue previously thought about an assessment. In other words, your point of reference is an earlier and different perception by the revenue. And you then said that must have been so when the word discovery was used in the legislation before self-assessment, and I think I can understand that. But if the word discovery has to be in an always speaking sense and to work in the world of self-assessment, why should it be a discovery that's different to what the revenue previously thought? Why should you have to interpose between the assessment and what the revenue say they've discovered about it, some previous thinking of the revenue, where there's a self-assessment? Where the revenue do the assessment, then by definition, you must be right. But where the taxpayer does the self-assessment, I'm not quite sure how that is the right interpretation of discovery, unless you simply say it had a settled meaning before self-assessment, and self-assessment doesn't change it.
The second is certainly right, but it's right for a good reason. Pre-self-assessment, the reason I'm peering, and I'm hoping it's not putting anybody off as I'm checking on my time. Pre-self-assessment, the revenue puts an assessment and assesses the taxpayer, and then it says, look, we got it wrong, here's the discovery assessment. In self-assessment, the revenue has visible to it a number, the taxpayer self-assessment. They will take a view. They will take a view as to whether that number is right or wrong. And they can inquire into it if they want. So they have taken a view to make an inquiry and close it, in which case you've got a reference point there. If they've said, well, we closed the inquiry on the wrong basis, or not to raise an inquiry, in which case you've still got a reference point, which is the original self-assessment. So there's really not a conceptual problem.
See that where they do in fact undertake open a section 9 inquiry. But in this case, they didn't. They went off on what, subject to a reservation made by your opponent earlier today, was a frolic of their own, and went down Schedule 1A. I think I got my numbers right. And they never did open an inquiry into the figure. They simply, on that face of it, must either be deemed to have accepted it, though I don't think they did, or to have accepted it. But you don't have the reference point of an inquiry that's been opened and then closed.
No, I don't. And in my respectful submission, that's not my problem. Because the revenue will have to say and show the FTT, that's the only relevant tribunal they would have to show, that they had a reference point, that they had discovered something. Because in a world where the self-assessment comes in, and I know I keep going on and on and on about this, they can inquire without cause. They don't need to discover anything. If they haven't, so they don't have a reference point, or there's no evidence as to what that reference point is, then that's the revenue's problem, because the burden is on them to show that they've discovered something. There was talk about bearing risk and the balance between taxpayer finality and good public administration and risk and protection of the revenue. The point I've just made, a textual point, that it's discovered by reference to what? By reference to a previous view. That's where you get the language of something new. New compared to what? So I'm not just relying on the pre-self-assessment authorities. I'm saying it fits in very well textually with the self-assessment regime. You compare to some previously held view as to the number on that self-assessment. So imagine this, which is pretty much this case. I've self-assessed at -13. It's an employment loss. You won't like it. You don't agree that I've got a loss. You don't even agree I can carry it back. You might even want to raise an inquiry. So right from the start, we differ. In those exceptional circumstances, it's not a rhetorical question and not a silly answer to say there's no discovery. The revenue were told from day one, I think X, you think Y. If you want to do something about it and disturb my self-assessment of X, then I'm ready. And why does that preserve balance? Because the revenue can raise an inquiry as long as they do it the right way. There's nothing preventing the revenue to raise an inquiry. They don't need a discovery. They're protected. In those circumstances, they don't need to change their mind because they always thought that the taxpayer self-assessment of X minus 13,000 in this case was wrong. The number was wrong. And that's the point. They always thought that. Precisely because it was a DOTA scheme, my Lord Legate.
Just so I could quite clear and following your argument, Mr. Ghosh, that I understood the primary way it was put against you was to say, well, Mr. Williams made a discovery and he was the officer who made the assessment, and that's all that mattered. Is your answer to that, do I understand, it's based on a corporate knowledge idea that Mr. Williams can't discover something if somebody else in the revenue has already discovered it? Or how are you addressing that point?
The way I address that is, and I say this rhetorically and respectfully, show me where Mr. Williams, in his email, said, well, I used to think that minus 13 was right. I don't think that anymore. And I think it's 455,000. He doesn't say that.
Well, why can't he discover it if he had no view about the matter? But when he looks at the return, he sees that there's an insufficiency in it. And his previous lack of knowledge about that becomes knowledge, and that's his discovery.
If that's what had happened, I'd deal with it. But there's no evidence that's what happened. And here, and that's the trouble with the way that the direction of this case. There's all sorts of things that Mr. Williams might have based his decision on, that might have made what he decided a conclusion which amounted to a discovery. Or it might have been that he, as in his own words, didn't know anything about self-assessment. He says that himself. But somebody's told him it's a good thing to do to start up a 9A assessment and then issue a discovery assessment. So there are all sorts of alternative universes in which Mr. Williams could have done a perfectly good job and say, I thought the minus 13 figure was correct. I don't anymore.
Would that be sufficient, do you say? Would that be sufficient for the revenue?
It would have to be. It would be sufficient if, and this is why I'm saying it has to be, a conclusion which was different to a previous view of the number, and a conclusion is dependent on reasons. And that would be sufficient. Yes, it would. And where is it? Mr. Williams' email, and this is why this is these are not the sort of submissions that you, generally speaking, you'd be making before this court. They've been sort of submissions you've been making in some sheriff court or some in the lower courts, which is, oh, there's been a lack of pleadings. Oh my goodness, it could have been. There is no evidence. All sorts of things could have happened. I say that the word discover, and this is a matter of principle and text as well as authority, there needs to be a conclusion, whether it's on, and that has to be different to a previously held view, that the number was wrong. Where is it? It might be that. It might even be that the extracts from the email would be consistent with that. But they're also consistent with Mr. Williams saying, I don't know anything at all about self-assessment. You're telling me that I should replace, his words, the Schedule 1A with a Section 9A. But I'm not going to turn my mind to this anymore. And that, I'm not hiding behind burden of proof. I'm saying in circumstances where I have a case to meet, that case has got to be properly put to me. What is the difference of opinion, the difference in view, the new thing, either because you've received new facts or you've taken a different view of the law? Your decision. And let me be clear, my Lord, this is really directed to my Lord Legate. That letter that I showed you, the 24th October 2014 letter, that followed from Mr. Williams's instructions. That was dependent not on anything other than the accusation that the loss was deliberately forced in on the basis of some culpable conduct. So that's a long response to my Lord's question, but the short answer is all sorts of things would, oh, my Lord Sales.
Yes, I mean, just on that point, wasn't that point being made because that was a condition that had to be satisfied to get into a discovery assessment, rather than necessarily saying that's the basis of the discovery?
My Lord, it might have been, but that would be a very bad behaviour on the part of HMRC because they're making a factual allegation.
But forgive me, don't they have to make a factual allegation that one of the conditions in section 29 is satisfied in order to get into the world of a discovery assessment?
They absolutely do. My point is, A, that was wrong and not pursued, and B, what else is there that is given, delivered as a reason in that letter? And this is pursuing actually both the points made by my Lord Legate and the point just raised by my Lord Sales. What other reason is given for saying I've discovered an insufficiency of tax?
Yes,
Bear in mind, please, that on the basis of advice, Mr. Tooth self-assessed at minus 13,000 because that's what he was told was the right number. He's done nothing wrong. So putting pressure on the word discover, and it might be a good time to pause. Putting pressure on the word discover, find something new when you're looking at the authorities. New compared to what? New compared to a previously held view, a previously held opinion. Opinion about what? Not the way to disturb a self-assessment, but the self-assessed figure itself, an insufficiency of tax. And all I'm saying here, please, my Lord Briggs.
I just want with you overnight to find a reference point where the revenue thought something different from what they say they have now discovered. In a case where there's been a self-assessment but no Section 9 inquiry, could it be said that the revenue, by not inquiring, must be taken to have accepted it, subject only to a later discovery?
It could be said, that could be said, my Lord, but it would always be a question of evidence.
Yes, I'm not really seeking an immediate answer, but thank you.
But one immediate answer, and I will return to this tomorrow morning, my Lord. One immediate answer is that's the problem with this whole set of submissions. It's always going to be a question of evidence. What did the revenue think? When did they think it? When did they change their mind? What made you change your mind? What were your reasons? And that's why I say, and please may I leave your lordships with this point. That's why it's a function of evidence. That's why in a world where the burden of showing this is on the revenue, one can actually postulate many different factual circumstances where Mr. Williams might have made a discovery using a correct reasoning process, and equally one where he didn't at all. But that is not for this court. And so that may be, if it pleases the court, a place to stop, and I'll pick it up again tomorrow.
Yes, thank you very much, Mr. Ghosh. We'll adjourn then for the day and resume at 10:30 tomorrow morning.
Oh, I'm sorry. Is it definitely 10:30?
Well, that's when we normally. I'm sorry, Mr. Ghosh. Had you been given to understand we might start at some other time?
I was told to turn up at 10, but that might be for a test.
Well, you're given. Councillor always sent an invitation to the electronic meeting at 10, just to allow plenty of time for people to join it. It's open, as it were, from 10, but it's 10:04, 10:30.
I'm very grateful. Thank
you. And the hearing won't begin until 10:30.
I'm very grateful. Thank you.
Yep.